Hello, 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 and good morning, everybody. I hope everybody is having a great day. We've got a pop-up hearing. This one was not scheduled until just recently. There's going to be a hearing today on several different factors. The prosecution wants everything sealed now. The defense is fighting it. The defense also has some other things that they want to fight. So we're going to get into this. We're going to see it happening live right here, you guys. So I'll give some shout outs and then we're going to go over some stuff that was filed recently. Patty Ward. Hello, hello, hello. Vera Ray. Juror 11 in the house. And Nana. As you do. Hello, everybody. Smash that like on your way in. Okay, so let me just get a couple of these things pulled up. And we're going to go over it. Which one did I want to show? Okay, so this is one of the ones. We're going to share this one first, you guys. I'll make it big so you guys can see. This is one of the ones that they are going to be discussing this morning. Hello, Kansas Terry. Lulu. Hello, hello. So this was filed by the defense. This is an objection to the state's motion to close hearing pursuant to ICAR 32 subsection G and proposed scheduling order. So this is also a scheduling order. Now, I haven't seen this one yet, you guys, so we're going to be reading it for the first time together. So comes now Bryan C. Kohberger by and through his attorneys of record and hereby objects to the state's motion to close the hearing to compel on May 14th. So they want the next hearing. Today's hearing, we're going to be able to see it because the judge has not made an order yet. So we will see today's hearing. Now, the next hearing that was scheduled a while back on the 14th, this is what they are trying to close this hearing. The grounds that Mr. Kohberger has a constitutional right to a fair and public trial. No reason exists to prevent him from a public pretrial proceeding, a proceeding to ensure fairness and access to the state's information. Furthermore, the state has made no showing that the hearing should be closed under IAR 32. There is simply no legitimate reason for that motion to compel discovery should be shielded from the public. The process of sealing is being abused by the state and its law enforcement agents. Well, it's usually the defense. I wanted everything under seal, but now they're saying that the process of sealing documents is being abused by the state. Well, I think the defense has done a lot of that themselves also, including the FBI to hide how discovery is being withheld in this case. Well, you can't tell the FBI. If the FBI doesn't want to give you something, you ain't getting it. Testimony and argument on information sought by Mr. Kohberger does not meet the narrow scope of what the state can shield from public view. Not only is there no authority to protect the FBI, other law enforcement agents, and the state in this matter, this request to deny Mr. Kohberger an open hearing is a clear violation of his right to a public trial. So now they're saying they want things all in the open. The prosecution is saying we want it all sealed. We want everything sealed so there's no more mishaps about what can be talked about, what can't, whatever. We're going to hear about this today. So it goes on to cite a case here, Weaver versus Massachusetts. If you want to go back and read that, you can. The state has failed to provide all the requested items that were asked for in the defense's supplemental request for discovery to support the charges against Mr. Kohberger. Thus, the defense has had to file its fourth and fifth motions to compel. Well, what they failed to state here is also they've been under an order for an alibi for over a year to give the prosecution their alibi, and they keep giving stuff that is already out there, like the GPS of where Bryan Kohberger's car was, him turning his phone off, stuff like that. That's already out there. That's not an alibi. And I feel like they are fabricating the alibi around what the prosecution has. If you have a rock solid alibi, that alibi is not going to change depending on what the prosecution gives you. It won't change. They're saying now that they're not going to give their full alibi until they get the rest of what the prosecution is waiting on. And it's not the prosecution's fault that the FBI hasn't given it to them yet. You can't force the FBI. The FBI does exactly what they want to do. So, and regardless of what is still waiting to be given over because they don't have it yet, and the defense has stated this many times that they don't blame the prosecution for this, they're blaming other agencies. You know, so why haven't you given your alibi? If you have a rock solid alibi that is true and honest, it shouldn't matter what you get from the prosecution or what you don't get. Give your alibi. They won't do that because they want to make sure that the prosecution doesn't have something that is going to blow that right out of the water. So, which means to me that it's fabricated. It's fabricated about what the prosecution can prove and what they can't. So, when they start talking about motions to compel, they should look at themselves too. Now, there's no real law stating what the defense has to turn over and when. The defense, to me, it's almost like they're waiting to ambush the prosecution with something so they don't have time to investigate it before trial. Just my opinion. Like I said, if I had an alibi that states where I was, and my alibi shows I was not near that house at any point in time, I would have given it at day one. Why are you waiting? An alibi, a rock solid alibi, is not going to change. The only thing that could change with it is, like, you know what? This person has decided now that they will testify for me. They didn't want to before, but now they will. You know what I mean? It's being fabricated. It's clear. Just my opinion. It is not lost on Mr. Kohberger that the state is asking for a scheduling order to obtain information from the defense to be used in support of our motions to compel the state's discovery. However, Mr. Kohberger suggests a dual deadline for both the prosecution and defense to file notice of witnesses, exhibits, expert reports, or other evidence relied upon in the fourth and fifth motions to compel by May 7th. Okay? So they want all this by May 7th so they can get their alibi to the prosecution fabricated around all the state's reports, experts, witnesses, exhibits. They want to see it all to see where they have room to fabricate some more of his alibi. Hello, Lady D. Okay. So the next one, it will be starting, you guys, in about 20 minutes. We're just going over these last things that were filed. So this is the response to the defendant's supplemental response to the state's alibi. Comes down to the state of Idaho. We're not going to go through all of reading every single little thing in here. We're going to go over the basics because this is 5 pages and we've got like 20 minutes. So by and through Latah County prosecuting attorney and submits the following initial response to the notice of the defendant's supplemental response to the state's alibi demand. Filed April 17th, 2024. Like, we've been waiting well over almost a year and a half now for this alibi, which we still don't have. The only thing we have is stuff that we've already had, like where his car was in certain aspects and something. And anyway, at the outset, the state incorporates by reference as it fully set out at this point those portions of the state's July 27th, 2023 motion to compel. A motion to compel for a notice of defense of alibi since July 27th. They still haven't given it. Alternatively, if they don't give it, to bar the alibi, right? To the extent that it relates to the adequacy and timeliness of the defense alibi notice. The state respectfully submits that the defendant's supplemental alibi response continues to lack specifically required by Idaho Code 19519, which provides that the defense shall state the specific place or places at which the defendant claims to have been at the time of the alleged offenses and the names and addresses of the witness upon whom he intends to establish such alibi. Emphasis added. Okay? So the defendant's April 17, 2024 submission minimally adds to the alibi notice dated July 24th, 2023. The defendant states he was driving around during the early morning hours of November 13th and drove throughout the area of Pullman, Washington, west of Moscow, including Wawawe Park. Des, there she is. Lady D in the building. So basically, he hasn't given anything else except for now adding, also including Wawawe Park. Well, that park is closed at dusk. So that blows that right out of the water for him. With the exception of the reference to Wawawe Park, which is new, the defendant is offering nothing new to his initial alibi that he was simply driving around during the early morning hours of November 13th, 2022. As the state noted during the August 2023 hearing, the state is aware that the defendant was driving around rural areas of Whitman County, Washington, and Latah County, Idaho, during the early mornings of November 13, 2022. In fact, the defendant's travel during that time are described in the original probable cause affidavit supporting the criminal complaint in this case. As to the defendant's reference to potential testimony about the location of the defendant's cell phone on the morning of November 13, 2022, this information does not rise to the level of an alibi at the time of the homicides because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. The location of the defendant's cell phone at times other than the time of the homicides is not proof of or relevant to the defendant's specific location at the time of the homicides. Right? So if they say he was at Wawawe Park at 5 o'clock in the morning, watching the moon and the stars, which we know now it was overcast. You couldn't see the moon or the stars. Wawawe Park closes at dusk and doesn't open until, 7 or 8 o'clock the next morning. So we know he couldn't have been in that park, and we know that it was overcast, so he wasn't there watching stars, right? Sorry for the cough, you guys. It's allergies, and I'm telling you, it is nasty this year. It is the state's position that the defendant's continued failure to adequately comply with the Idaho Code 19519 subsection 1 does not trigger a response under Idaho Code 19519-2 if the court deems the defendant's supplemental response to be in compliance with the requirements of Idaho Code 19519. The state requests additional time pursuant to Idaho Code 19519-5 to prepare a list of witnesses to establish the defendant's presence at the scene of the homicides. As to witnesses to rebut the claim of an alibi, the defendant's failure to adequately comply with the Idaho Code 19519 means the state does not know what specific assertions it needs to rebut, which is true. You can't ambush them. This says she's at the doctor. If the court allows the defense to offer further witnesses or information regarding alibi, which the state opposes as described below, and bring it into compliance, the state will then respond accordingly pursuant to Idaho Code 19519-2. It has now been approximately 11 months since the state filed its request for discovery, disclosure, and alibi demand in May of 2023, a year ago, and almost a year and a half since the homicides occurred. The defendant has been given more than he is legally entitled in order to provide his alibi. The state substantially prejudiced and compromised in its ability to investigate and respond to new or additional alibi-related disclosures. So do you get that up until this point? Sorry, you guys are really had a cough there. As the Idaho Courts of Appeals noted in State versus whatever, the state has a legitimate interest in obtaining timely and complete discovery response from the defendant. The state respectfully submits that we essentially remain in the same position as in July and August of 2023. We don't know, like Juarez, I know I'm killing that, but we don't know how this is an alibi at all. As the state further noted in its July 27, 2023 motion to compel, notice of defense of alibi, or alternatively to bar certain evidence, the United States Supreme Court has observed in Taylor versus Illinois the ease with which an alibi can be fabricated. Right there. Okay? And that's what I think they're doing. They're fabricating their alibi around what what the prosecution has. That's not an alibi. If you have an alibi, it doesn't matter what the prosecution has. If you have a true and honest alibi, it doesn't matter what they say. Give your alibi. It's because they're fabricating around the evidence. And the state's interest in protecting itself against an 11-hour defense is both obvious and legitimate. And I agree. Based on the above, the state respectfully requests that the court enter an order denying the defendant any further opportunity to add any purported claim of an alibi and preclude testimony by anyone other than the defendant as to the defendant's absence, form, or presence at the scene of the homicide. Hello, Isabel. Welcome, JJ. Hello. So those are the new documents, you guys. And we are waiting for, let me just get this over here so I can keep an eye on it. So when they do start, they're about to start in about 15 minutes. I did start the live a little bit early so we could chit chat a little bit about this, so I could show you the new filings. And whatnot, but I do have it up and we are waiting for it to start. We've got about 15 minutes before it's to start. So I do have it up and waiting. As soon as it is, where did that just go? Hang on, give me a sec. Okay, here we go. As soon as it starts, I will bring it up on stream. So yeah, like you can't ambush them, you know, and like I said, they've had a motion to comply for a year now. A motion to compel, sorry. A motion to compel for over a year now. And yet the defense is, okay, we want this, we want this, we want this. We know it's not the prosecution holding it up. We know it's the FBI, or we know it's this, or we know it's that. There's more stuff coming out about the IGG, you guys, but it's sealed. That's going to be brought up on the 14th. They want all the information. They figure, the defense has figured what they did get from the prosecution regarding the IGG. They're saying it's not good enough, that they want it all, right? Okay. Sorry, you guys, but when I do have to cough, I will be muting myself because you guys just don't need to hear that. You don't need to hear it. Hello, Isabel. And Tay. Patty Ward, hello, hello. Like I said, you guys, we are waiting for this to start. As soon as it does, I will put it up on screen. Let me just make a banner here. Okay, so I'm going to put that. I'm going to mute myself for a minute, you guys. I just got to go and help the elderly gentleman that I rent a room to. I just got to give him help for like 2-3 minutes. So just give me a couple minutes and I will be right back. Feel free to chit chat with everybody in the chat and I will be right back. Okay, we are back. Oops. All right. Shy. For those of you who may not know, my name is Shy. I am a female. I'm happy to be the honorary foreperson of Willow's Court. I'm also a member of the jury. I am juror 11. I love it. I love it, Shy. Yep. We are going to be starting momentarily. Like I said, I've got it up on my other screen, so as soon as it comes on, I will be putting it up for you. It has not started yet. As soon as it does, I will be putting it up on screen, you guys. So what do you guys think of, I'm going to go over something that I seen regarding the Sebastian Rogers case also. Have you guys seen the picture that's out that apparently he's like standing on some rocks and stuff? Because there's more pictures that have come out regarding that. And to me, it's all fake. Somebody's done some really good photoshopping. Yes, in North Carolina. Somebody's done some really good photoshopping. And I'm going to be showing that. Now, let me pull it up right now. Let me just pull it up quick. Instead of doing a full live on it, I'm going to pull it up and show it to you, what I'm talking about. If I can find it again. Here it is, right here. Okay, let me put it over here. And I'm going to show you this, what I came across. Okay, can you guys see my yes? Okay, so this was sent to Jennifer Coffendorfer, okay? So she says, one of our top-notch sleuths took many photos of that area for us to compare. Below is one showing the step down to show the awkwardness. I see questionable shadowing, foliage differences, distance issues, but I pray it's him. Now, this is one of the photos right here. But you can see skinny, skinny, skinny pants on here. I think this, look at how long this arm is from the shoulder all the way down here. This looks extremely long to me. That's one thing that stood out to me. Another is look at the shoes. They're like a light color, almost as light as the white. And they go around the front. There's no little lip coming up on the tip of his shoe. Like I've blown these images up. There's no little lip coming up, nothing. Now watch this, okay? Yeah, they're way too dark. And the picture itself is way too dark in contrast to the other things around him, okay, with the sun shining on. But watch this. Here's a picture that was sent, and here's another one. What do you guys see? These shoes are dark gray. This is jeans, and this person looks a lot bigger. Look at, I can tell you the shadows are there. Look at, the shadows are there. So the person sent another picture. But look at, this person has jeans on. It looks like a cell phone in the pocket, and this person is shorter. You can tell by the length between the knee and the foot. This person has jeans on, and this is, to me, somebody who's a lot heavier than Sebastian. Like, look at, this is no way. Not even the correct step down. Look at, he has black skinny jeans on here. Look at, they said they zoomed in on the foot going down. Not even the same. His foot in this picture number one, isn't even touching the curb yet. And he's not wearing jeans and he's not that chunky. And there's tons of other things I've seen differences in these photos that they took. Like somebody went the next day and took a photo. The foliage is different. I know there's nothing on the trees, but you look at these bushes here, how thick they are. Okay, you can see like the orangey color type thing. And here you can't. The heights in the trees, okay, compared to the one with Sebastian, it's not the same. And apparently, after this picture came out, like a day or so later, people went there and they took this picture. The foliage is not the same. Even like this dark green, look at how dark green this grass is. This is a couple days later. It's not, it's more brown. There's a little bit of green there, but this is more brown. Even these things, more brown than they are in the actual pictures that they say he's standing right here. And the fact that this person is wearing jeans when Sebastian is not wearing jeans and he is not that thick. The shoes are different. They got this lip coming up. They're a dark gray. Let's go see Sebastian's. Sebastian's are a light gray and they look almost brand new. He's not touching that yet. He's wearing black pants. The foliage is different. The colors are different. Look at how green all this is compared to the person who went there. Look at the brown, all the brown. I don't know who would Photoshop it, you guys, but I just wanted to briefly show that to you as we're waiting for this court to start. That should be starting at any moment. I don't know who would do that. Okay, different time of the day, different angle. He wasn't wearing jeans. He was wearing black pants. His shoes weren't dark gray. They were very light gray, almost a white. They had no little lip coming up on the front. And he was not as thick as the second picture they show. Look, it will show you close up. Well, that person's wearing jeans. And has a lot more weight on them than Sebastian. And the pants themselves. Sebastian, in the picture they showed, Sebastian was wearing skinny black, either jeans or sweats. They were really skinny, tight to his leg. The other one was somebody with a lot more weight on them wearing blue jeans, very baggy blue jeans. Like, I'm not saying baggy, but like you can see how thick the person's leg is. Yes, just in time. It's about to start. I'm just waiting for it to come up on the feed here. And this may be one of the last ones, you guys, that we can see live because the prosecution is wanting to seal everything. So we are waiting momentarily. And like we know, the court never starts on time, right? And like I say, I keep refreshing it here. And so far, they are not up and live yet. Well, I guess it's not the first time they've tried to do something like this either, right? With Sebastian. Look at that guy that said, I have him. He doesn't want to go home. Hello, Mom Otter. We're just waiting for court to start. I do have it up on my other screen. As soon as it starts, I will put it up on screen. I've got all the volume cranked right up. It is. It's so cruel. It is so cruel. And I think it's somebody that's really good in photoshopping that puts Sebastian there. And like I said, I just got all those photos I just showed you. I just got them this morning. So I just seen them. So I want to save them and then blow them up to see what else I can get. Yes, I agree, Kate Bell. Trolls are everywhere. So again, they're going on 5 minutes late. Are we surprised? And oh, there it is. Okay.
Nine is
Put one in the chat, you guys, if you
participating
can hear it, please.
remotely. And I don't have a few things just to sort out today. The first thing I want to talk
Okay, I'm gonna
about
mute.
is whether or not this hearing should be sealed. What's your position, Ms. Taylor?
Your Honor, this hearing should not be sealed.
Okay. Mr. Thompson? Ms.
Well,
Jennings?
Your Honor, the state's prepared to do its argument today without actually talking about the specific request that we're trying to protect within the discovery request. And so as long as those specifics are not discussed or mentioned, then I think we can go forward with an open hearing today.
Okay. Are you comfortable with that, Ms. Taylor?
Well, what I'm not going to talk about is the content of the court's protected materials that we've asked for a sealed hearing for. What I'm prepared to talk about is why should we seal this particular motion to compel that's set to be heard, and how much else is in the public record, and why there's no compelling reason to seal that, and why that violates Mr. Kohberger's constitutional rights. So if I talk about things that are in the affidavit, and if I talk about things that we're seeking that the state wants to hide, I think that's fair game for the public to hear.
It's the challenge here is that both sides have agreed to seal all the discovery. There's a lot of stuff out there, and so I hope that you can both honor that at this point, because down the line, maybe some things do have to discuss. We need to discuss very specifically that maybe both sides don't want that out in the public, because it is a fair trial goal here. And if we start arguing about the case itself, the trial, and the evidence that you're gonna present, both sides, gets more complicated and may be prejudicial to one or the other. So I guess at this point, we'll keep this open, but be careful. I mean, I've read everything, so I know what's sort of out there and what you're concerned about. And some of those materials or potential evidence could be prejudicial to the state, or it could be prejudicial to Mr. Kohberger. So my job is to try to keep on a balance here, a neutral balance, where when we get to the trial, if we ever get there, that it'll be fair and we'll have been determined in advance. Okay, so keep it open today. If something comes up and we need to close it down for a period of time to discuss a particular situation, then we can do that. Okay, so it really, I think at this point, it's the state's motion to close the hearing completely on May 14th. I believe, I'm not incorrect, that you both have stipulated to closing May 16th, which is related to the IGG.
Your Honor, our position is that's the only part that should be closed, and that's because we want to talk about the content of the materials protected by the court's order, and so that one's appropriate to close.
Okay. Okay, I think I'm on the same page, but great. Okay, Ms. Jennings.
Thank you, Judge. So, Judge, the applicable authority today in determining whether or not we should close the May 14th hearing is Idaho Administrative Court Rule 32 and Idaho Code 74-124. Both contemplate balancing this public right to an open hearing versus the interests such as privacy, safety, and the right to a public trial or to a fair trial. In deciding whether or not to file the motion to close the hearing, the state weighed those interests and ultimately came down that the need to protect the privacy and the sensitive information and ultimately protect the state and defendant's right to a fair trial outweighs the right to an open hearing. Feel confident that when the court does this same balancing test, it'll come to the same conclusion. For the record, since the beginning of this case, attachments detailing the specific discovery request have been filed under seal. In line with this, on April 4th of 2024, just about a month ago, the state and defense filed a stipulated motion to file all future attachments under seal. Today, we're specifically discussing the defendant's fourth and fifth motion to compel discovery. Concurrent with the defendant's fourth motion to compel discovery, the defendant motioned the court that the details be filed under seal, citing Rule 32. Concurrent with the fifth motion to compel discovery, both parties stipulated to filing the details under seal, citing Rule 32 as well as Idaho Code 74-124. So the state followed course. We have filed all of our responses under seal and then filed this motion to close the hearing to discuss those previously sealed details. Now the defense is taking a contradictory position and asking the court to ignore all the previous filings. And this is just entirely inconsistent. To be clear, the state has nothing to hide. However, it's crucial that we protect, as we have been trying, the integrity of this case, and that we protect, ultimately, the right to a fair trial. So let's look at the factors. Balancing a public's right to an open hearing and the party's right to a fair trial. Let's go to the factors laid out by Rule 32 and Idaho Code 74-124. And when we do that, for a defense's fourth motion to compel, Item 1, Subpart A, discusses federal grand jury materials. Those are exempt from disclosure by federal law, as well as Idaho Code 74-104, subsection 2. What they specify as subparts B through N, all of those items discuss evidence related to this investigation, of which disclosure would, 1, interfere with enforcement proceedings pursuant to 74-124, subsection A, deprive the defendant a right to a fair trial and the state, subject to 74-124, subsection B, and Rule 32, subsection E. And it would disclose investigative techniques or procedures which are exempt, pursuant to 74-124, subsection E. For defense's fifth motion to compel, Item 1, subparts A through J, all deal with the investigation. All would be exempt pursuant to the same authority just cited. Subparts K through M deal with the names of private citizens who were interviewed, and disclosure would constitute an unwarranted invasion of personal privacy, subject to 74-104, subsection C. It could contain intimate facts or statements of which would be highly objectionable to a reasonable person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32, subsection 3. Subpart N through O is exempt under interfering with enforcement proceeding, depriving the defendant to a fair trial, as well as disclosing investigative techniques or procedures. Item 2, subpart A, names a private business and is exempt under the previously cited authority. Item 2, subpart B through L, deals with the investigation, again exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsection, 74-124A, B, E, C, as well as Rule 32-12A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B deals with the investigation and is exempt under those same authorities. Item 4 deals with IGG information, which has been sealed and is under a protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to preserve the right to a fair trial for both parties. The defendant does have a right to a public trial, but that does not mean the right to try this case in media. The defendant will get his day in court, and the public will have a right to see what evidence the state has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's 4th and 5th motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
Tomorrow,
right, but our motion was filed over a week ago.
right.
So everyone's been on notice of what the state was asking for.
Thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because I've read through all of the 4th and 5th, and it's, I mean, some of the information it seems anyway. I mean, it's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those 4th and 5th, and the court's referring to our motions to compel, not discovery requests themselves, but they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 14th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74. And those really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, it's been brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people can read. And we filed those under seal for expediency in saying this is exactly what we want from discovery. If the court looks at the documents, and the court can and probably has through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so for expediency, we filed those under seal and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing when the state has decided to not give us information or to drag their feet on giving us information. We're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's his Sixth Amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment right to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. And the specific case, there's a couple of Idaho cases, State versus Kimbley and State versus Olivine, and they refer the court to Waller versus Georgia, and that is at 467 U.S. 39. And that puts forth the test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect what the state's doing. And the court should look back through the history of this case. This is our fourth and fifth motion to compel. Motions to compel 1, 2, and 3 were public. They were right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself why. And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these motions to compel are things that are outlined in the probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context. That's what they're doing when they want us to do this in private and not let the state know about the full scope of the videos that are out there that they haven't given us. That is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Your Honor, I'll give you a couple of examples. The state filed last June its motion for protective order of the IgG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Kohberger in it. So that's out there in the public. But that order was to protect information, the IGG information, that they say details how the state got to Bryan in the first place. That's been sealed, that's fine, we respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public can't hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in their probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they've withheld the audio from a great portion of that, and that it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents are filed under seal, that's fine, those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of this case. It really ignores the fact that Bryan has been essentially convicted in the media. You don't have to read but a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that people can see it's not this neat little package. So people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent. And he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor. You know, I don't know where did it stop though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, or stop? It just is a roll of that. And so either side, okay, that it sends to the public that it is not, you don't get the context. They don't have the context, the public. You have the context. You want more context. I get that. But it's really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand that Mr. Kohberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to answer that.
I do, Judge. The Waller versus Georgia case is in the context of a motion to suppress. If the court starts closing hearings now, when the court hasn't closed the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped bits of information with different filings they've made all throughout the way. This can't be done in private. It just can't.
I would say both sides have said in their motions or in their briefs that they've disclosed, certain things. And it's a change, see, that because both sides have agreed to seal a lot of these issues of evidence in the discovery. And so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like this isn't about discovery, this is about the hearing.
Your Honor, those are discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about. And these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record they're different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve. Public has a right to see how its business is carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 from the public eye. All of a sudden we get to 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within their possession and control that we need to prepare our case. Your Honor, I would ask the court to consider too how much pressure there is to get to trial. We've heard the state say they'd be ready by this summer. We've heard the state say they're going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. They're just not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure of let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no change in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Ms. Taylor. Response, Ms. Jennings?
Yes, Your Honor. Ms. Taylor's argued, and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a day for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial. And yes, they extended it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're contemplating discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that, Ms. Taylor?
Well, Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in us receiving documents that the court had a protective order on, and we can't even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public eye. In that particular hearing, they talked a lot about DNA results on a knife sheath. That I'm sure benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records that exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower information, and the things that they have not given us, the drive test information, the verification of such.
That's the thing. I don't want to talk about those particularly. And I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in this position where I have to make decisions blindly to some degree, and that's what the case with the IDG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about there's a lot of stuff, okay, that you're arguing about, and the state is arguing about, and I think it's complicated to just open that up. I think that, maybe we could go through a closed hearing and then open up what you feel needs to be opened up. But I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and I thought, how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of issues. I would ask you to look at the probable cause affidavit and read the parts where they talk about relying on FBI agents and the CAST report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas, deuces taken to the FBI. I mean, it's really difficult to get information from the FBI. You know that, they know that, I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things that, we can maybe address that today too. I'm thinking that you don't have an objection for me to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that today.
You can sign that. You can sign that. Anything you need to sign to get us the things we want, please sign.
I'm with you. I'm trying to do that, and from what I've seen, I think the state is trying to do that. I know that it's not satisfactory. from your position. But
And
there's
those-
a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th, is the timing of these things,
Right.
not the full content of what we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial, and Your Honor also is aware of all the things that we have to do. And when we make a request and months later, you're asked to sign the order so that maybe we can finally get that information, that timing part is important for the public to know. That's not the content. I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us being ready for trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit that has been on the court's public website for a year and a half now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done with this issue.
Okay, thank you. I mean, are you expecting to make the decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. And if I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. I don't agree any part of the hearing should be closed. And I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks, is that right? 14 days?
We're less than 2 weeks. We're 12 days.
All right, well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm gonna close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you aren't getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are holding with the FBI, and that we need to get that. I mean, those are all really complicated processes. And I would feel much more comfortable when, again, I'm trying to protect a fair public trial and not have a maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the balance for me. That I want to see what all the issues are, the arguments from both sides, so that I can make a more informed decision. So I'm going to close the hearing. At some point in that hearing, maybe we can open up part of it. But I need to dig in, and you all need to dig in to exactly what is the problem with each one of these issues. All right, so let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you've got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. That seems more practical. Okay, so I will put an order out, schedule order for providing I don't know if the state really knows what you do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports, or exhibits at this point because you don't know what to expect.
Right.
And this is related to the hearing on the 16th, right?
In the 14th, I'm not sure.
Okay. And there may be witnesses on the 14th too, as well?
Yes, Your Honor.
Okay. All right, so let's make it May 7th for disclosing witnesses, expert reports and exhibits. We'll see what the state has to do with that. And we'll have a response maybe May 10. Is that sufficient? It's tight.
Well, that gives us 3 days to respond.
3 days. Yeah, that's right. Well, May 10 is I don't know when I'm gonna read all this stuff too, because it's 14th, so if I don't have it by the 10th, then you're saying the 13th. I guess I can do that the night of the 13th. But also, the defense needs some space there too. And I don't think we want to push out that hearing. Can't do it by the 10th.
We have no idea what the defense plans
Right.
on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with the 13th then.
Yeah, I mean, we can try, and then if we
Okay.
need more time, we'll ask for more time.
It's just then on my end, you're looking at, I'm gonna have really more, I'm gonna need more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay,
I don't expect there to be reports.
exhibits.
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, timeframes because we also have other things to do, but Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. Names witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case of last minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If they're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just a name. So what's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay, well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, or whatever you want to say. Otherwise, I just need to push out this hearing. I'm stuck.
I appreciate that, Judge, and if I guess we've said it before, it is more important to do it right than to do it quickly if we have to have a trade-off here. And that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings, that apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say, and then we're expected to react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
Your Honor, I'm expecting to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from the protected materials that the court allowed us to have already. There will probably be one or two other exhibits, maybe two, that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be two witnesses on that hearing, one for sure, possibly a second. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And that's, I mean, it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you don't have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do for the record need to clarify, the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived, we are continuing every week to provide additional discovery. We have more discovery coming. We hope that much of what they felt they had to file a motion to compel on, instead of being patient and wait, because our discovery deadline isn't until September, that we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little, if anything, we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we have been trying consistently through cooperative efforts, as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas ducis tecum isn't the first TUI process, and the court is aware. We've been pursuing TUI process for all types of information for months. So the characterization that we are just consciously withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, many of the things that the defendant has tried to itemize, when we talk to our people, they say that doesn't exist. So, I don't know what we're supposed to do at that point, and we'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to go find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of them.
Thank you, Your Honor.
Your Honor, I want to respond to that, and I can give you particular examples of things. And it's already been ordered to be given to us, the CAST report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things, Your Honor.
Oh,
that's there.
You know what? Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything. That's what the state was saying. I trust both of you, okay, your integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want y'all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues. That's
We're happy to, and when we get the cash report, we'll disclose it. If we do not have it, we are not withholding. As simple as
I
that.
read that last night. Okay. I'm very prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration. And it's a big deal. It's
It is a
really
big
important. I understand that too, and I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th and probably at the 16th too. Okay. Moving on. We've got all right, some of these pending motions, there was no request or no response from the state. And I'm thinking that the motion to unseal parts of the IGP materials and motion to allow defense investigators to review the IGP materials that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's the state's understanding, Ms. Taylor?
Yes, Your Honor. Well, we're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for a hearing, or if we just kind of let that lie for now. I don't know. What was your intention there, Mr. Thompson?
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just
Stick
wait
that
until
calendar.
the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything, Ms. Taylor. It can read your mind sometime, maybe not. All right. Okay, I'm going to sign those subpoena deuces taken. The FBI. I believe that's related also to the 13th supplemental. Maybe I'm kind of losing track.
Your Honor,
Well,
it does relate to one of our discovery requests, and I'm sure one of the numbered motions to compel. I'll note that when I speak about that on the 14th.
Okay, great. All right. Are there any other issues that we need to address today? Mr. Thompson, Ms. Jennings? Okay, Ms. Taylor?
Yes, Your Honor.
Okay, go ahead.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week. And the court could vacate those hearings if neither party notices something up for that hearing, there would be 14 days notice for either party if we have hearings on that basis. But that way we could notice up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for a hearing and waiting to find that out. It would speed things up to have 2 times a month that we would know if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's our request, is that the court just preset a couple of hearings. These would not be like the lengthy motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right, thank you. I actually mentioned that at one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication, okay? I don't know, maybe you are having good communication with each side. It is hard, to get a hearing when the clerk has to contact you or contact Mr. Thompson, and this goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases, and I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. So that's a good day for you, right?
Thursdays are fine, Tuesdays are fine, Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make that work. I just think it's more important that we have a place to put these hearings so that everybody's not spending a lot of time asking each other what day's okay, what time's okay, that we just all know that this is the time. So whatever day works best with the court schedule, Your Honor, is just fine with me.
Thursday afternoon is probably,
That'll work.
Monday is impossible. So what do you think about that, Ms. Jennings?
Yeah, that makes sense. I think Thursday afternoon be fine for the state.
Do you think twice a month? It's probably gonna ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. This is why I suggested that, and to know that we have those to iron out issues that are going to arise. Again, these aren't for the motions to suppress, those will come later.
Okay. Maybe we'll start with twice a month to get through all this discovery. I mean, I hope we can all get past that soon. And move forward a little faster. Okay, anything else then?
No, thank you.
Okay. Okay, great. Well, thank you all and have a good day. Beautiful day. Thank you.
Well, and that is that. Well, Grimmy says, she reminds me of another lawyer down in Ada County. I'm actually surprised at what John Pryor is doing. He is running circles right now around a lot of this case. Like, he's like got his oomph back, because I've always said, although I didn't like some of the things John Pryor did in the Daybell case, when it's come to now this trial, he's doing pretty good. He's I think put some doubt in the jurors' minds. Now, there's still a lot to go in that trial, you guys. I haven't really been able to follow a lot of this because I have so much on the go. But I think that he could very well put some reasonable doubt. But we'll see what happens there. As far as this case here, I think I would have really had a different opinion of Ann Taylor if she not pulled a lot of the back door and downright disgusting some of the things that she's done. She cries foul for something she created. She wanted this all under seal. I don't want my client tried in the court of public opinion. I want everything sealed, but now she's crying foul. How she tried to go back to 1800 law, and this was months that she wasted trying to change hundreds of years of how a grand jury comes to an indictment, right? Wasted so much of her time that she could have been preparing for this trial, and the court's time, the prosecution's time. I get that she doesn't have a lot of the information that is still needed. There's like 5%. Is it as big as she's making it out to be? We don't know, because we don't know exactly what it is. She's now wanting more IGG stuff. That was done and over with months ago. This is what she was given. She tried to take it to the Supreme Court. The Supreme Court shot her down. And now she's trying to bring it up again, wasting more court time, wasting her time. She's saying, oh, there's so much to go through and blah, blah, blah. I can't get through all these documents and pictures and this and that. Stop trying to beat a dead horse. Put your time into doing your defense and going through this stuff instead of trying to change laws that have been law for years, mega years. You know, I do, Lucas, don't get me wrong. I do respect that she's trying to do her job. But when you are hindering your own self from doing your job and then crying foul and trying to pin it on everybody else but yourself, I have a problem with that. The way she talks to the judge, in my 30 years of working in criminal law inside courtrooms and everything, I have never seen an attorney talk to a judge the way she does. Ever in my 30 years. Ever. Talking over top of him, telling him how to do his job. And he gives in a lot of the times. So disrespectful, so unprofessional. And why this judge has, yeah, exactly. The judge bends over and takes it up the you know what. And it's like, I get it. He's trying to keep this from going to a mistrial or for, you know, appellate issues and stuff like that. But there's a limit. And I think she has crossed that line so many times. And because she is going to continue to press it. You know, like when you got a child and you let them overstep boundaries and they continue to push those boundaries just to see how far they can push. That's what Ann Taylor's doing. She's gotten away with it for so long now. She just thinks that she's judge, jury, and executioner. Nothing else matters except for what she thinks, what she wants. And I do believe that she's doing a lot of this because she's made it clear. I want this trial, Judge, summer of 2025. There is no ifs, ands, or buts about it. I will not be ready until then. I'm not going to be doing this. Anything else, I'm going to fight it. And she keeps bringing up crap like this to prolong things so she gets that 2025 summer that she wants. Again, to get what she wants. To what extent do you push things professionally? And I believe you pull out all the stops in going for your client. I worked for criminal defense. I wasn't on the prosecution side. I was on the defense for 30 years. I get it. But there comes a time where I start cringing. It's like, are you still going to try and push those boundaries. The unprofessionalism is what gets me. There is a very, I'm going to tell you, there is a very fine line. And even in my own dealings, I've come close to that line, but I've never crossed it. And I think she's crossed it several times, and the judges let her get away with it. So now she's going to continue to see how far past that line she can push. In the beginning, she wants everything sealed. I want to protect my client. Back then it was client. Now it's Bryan. I'm waiting for her to call the judge, John. So unprofessional. And then it was, she wants everything sealed. Now she wants everything unsealed. You know what I mean? It's like, how far can I push this? How much can I fight on these different aspects that I created just to prolong things so I get my 2025 summer trial, right? So it's like, well, if that's the kind of, Lucas, I did some comments I agree with, and others, it's like, for somebody like myself, like I said, I'm retired now. I'm 60 years old now. I retired a couple of years ago. And in my 30 years, I've never seen a lawyer talk to a judge in the manner she has. And if you feel that, go and keep disrespecting, that's not how it's supposed to work. And I have no respect whatsoever for that. You know what I mean? There's a level of respect that you are supposed to use when you are talking to a judge. Number one is you do not interrupt a judge when he is speaking to you. You do not tell a judge how to rule his courtroom. Number two big things right there. You don't argue once the judge has made a ruling and argue with the judge and, no, judge, that's not what I want. This is the way you should. No. And she doesn't. That is disrespectful. So disrespectful. Regardless of anything else she has done, the way she talks to this judge and degrades others that are her equal or above, like the judge is above both the prosecution and the defense. There's a level of respect there that she crosses, not only with the judge, but with the prosecution also. She'll sit there and call the judge almost like dumb. And the prosecution, but don't do that to her, because then she's going to pull a hissy fit. Like, there's a level of respect there that she has crossed. And if you can't see that and you agree with that, then I don't think my channel is a place for you, because this channel is all about respect. Respect. You respect. And that's why I've let you go and say what you've wanted to say, because I love a good debate. You weren't attacking anybody here in the room personally or myself, and I respect that. And I respect you for that. Just as the same as I would respect Ann Taylor a hell of a lot more than what I do, and which is very little at this point, because she's not respecting somebody who shouldn't even have to demand it. It's a given. You respect the judge. Okay, Lucas, you're saying she has been trying to get information, but you're being so one-sided. That is such a one-sided comment, because the prosecution has been waiting for well over a year also for information that was ordered to be turned over. And still a year later, she hasn't. So be fair. It's not just one-sided like a lot of these Bryan Kohberger supporters, and I'm not saying you are, because you did say you think he's guilty. Don't be one-sided. What's good for the goose is good for the gander. I think a lot of the times he gives in because he just doesn't want a mistrial. And he's trying so hard for appellate issues. He's being careful about it. But there are times when he should have opened up his mouth and said, Miss Taylor, I am speaking. Sit down until I'm done and then say what you want to say. That is what should have been done. He never even should have had to do anything like that. He did kind of go in that direction there for a second, and I thought he was gaining back control of his courtroom. But Ann Taylor, in the position that she's in, should not have to be told to not yell, raise her voice, argue with the judge, or overtalk him while he's talking. And that is where respect is not being shown. I'm not even talking about information not being turned over by either side, because they're both doing it, not just one side, they're both doing it. I'm talking purely right now on respect. And the one person in that courtroom that has the biggest respect over everybody is that judge. And this is what you're missing. Okay, so the judge needs to sign what he needs to sign to get things done and get the information coming logically. But you're not even totally ignoring everything I just said about the respect factor. There's a certain way you can go and do it. Can she say what she's saying? Yes, but say it respectfully. Give the judge the respect he deserves. Give the prosecution the respect that they deserve, and give everybody the respect that you are demanding, Ann Taylor. Respect is given but once, and then it's earned. When you can openly disrespect a judge and prosecution the way she has, she should be not given an ounce of respect back. You give what you get. And I think it's coming time, like there's going to be a blow up here. There's going to be a huge blow up here. The prosecution, they have a right to defend any motions that are filed, just like the defense has a right to defend motions that are filed. Each should be given equal amounts of time, which is not happening. So let's be fair. If you want to talk about fairness, it can't be just fair for the defense. It's got to be fair for all parties, not just one. Anyway, there's my rant. I would never in a million years ever stand up while a judge is speaking and try and overtalk him, and not only overtalk him, call him wrong with what he was saying. The judge's orders are a judge's orders. He is a judge for a reason, and you're a defense attorney for a reason, and you're a prosecutor for a reason. You're not the judge. The judge is the judge of everything. Don't bring religion into this, Lucas. I'm saying, you were saying in the chat, I don't know you, but I'm judging what you say, not you. I'm judging what you were saying based on what you said. It's not fair to Ann Taylor. I'm attacking what you said, not you. But don't start bringing religion into this, because it has nothing to do with religion. I know Protestants, I know Catholics, I know Christians. Some are good and some are bad. Don't bring religion into it. We don't do that here. Religion and politics, we don't bring that here. We don't bring that here. If you can't debate what's being said without bringing politics or religion into it, then you're showing your hand. Green, hi, I've been a while, just moved, missed you. Well, welcome back. Glad you're here. Okay, so there you go. I'm simply saying that if you think Ann is being respectful, then you would be the one to not show respect. And I agree. We're not attacking you. We're attacking what you said. You said that you think Ann is being respectful. If that's what you call respect, then I don't know what you base respect on. If you can't respect, if you're a lawyer in that courtroom and you can't respect what the judge is saying, not to overtalk him, yell at him, or disrespect him, what do you base respect on? That's what is being said. We're not saying we know you. We're basing our opinions on what you said. So if this is what you've been commenting about, what I've got on screen right now, Lucas, we are commenting on what you said. You think that Ann is being respectful, and she's not. I don't know any lawyer that would ever say she's being respectful when she's over talking the judge and telling him he's wrong. And well, that's not what I wanted, Judge, and I think you should order this. That is not showing respect to the judge. Are you going to go to work and tell your employer how he should be running your business, and you're not going to do it any other way except for the way you want to do it? And that's the way that you should change your business to run the way I want it to run? No, you'd be fired. And that's what we're attacking, is what you said, not you. And then you decided you wanted to bring religion into this. Don't do that. Again, it's not about Ann doing. I agree. Ann is doing everything and anything she can for her client. So I agree with that part of your statement. But you still haven't addressed the disrespect she is showing to not only the judge, but to everybody else on the prosecution side also. That's what you won't address. And you lose my respect when you disrespect a judge like that. This is about respect. I'm not saying she ain't doing her job. She's doing everything she can and some, including bringing in 1800s law and then crying that she doesn't have the time to look through all the materials. She's complaining about something that she did to herself, is what I'm saying. Am I saying she's wrong to do that? No, maybe that's the only thing she could do at the time to try and get that indictment thrown out. Was it the right thing to do? I don't think so. If you're going to complain later down the line that you don't have the time to go through all this stuff because you spent so much time throwing something at the wall that you knew damn well was not going to stick. But she did it trying to pull out all stops. So yes, I agree. She's trying to do anything and everything. But at what cost? Okay, hang on a second, guys. Sorry about that, you guys. Yeah, that was my phone. That was my doctor's office, so I had to take it. Otherwise, I just would have muted it. I mean, there's a limit. There's a limit. But don't do something to hold up and take all your time that you know is not going to change, like how the grand jury comes to their conclusions if they're going to issue an indictment or not. It's not going to change. She knew she would never be able to change that law. She then went to the Superior Court after Judge said no. She went to the Superior Court and they shot her down too, and she's still trying to fight that. Like, at what point do you stop trying to do something that you've been shot down time and time again? The judge said no. Superior Court, she went above his head and they said no. Stop wasting your time. You know you're not going to change this law or how the grand jury comes to their conclusions. You're not going to change it. It's been like this for hundreds of years. Now, stop it. Get into your paperwork that you need to go through to start building your defense. But don't come back now and blame everybody else for you not having the time to do what you need to be doing. Yes, I do, Lucas, don't think that I did respect her. It's like, oh, you got balls trying to do this, what she's trying to do by, number one, trying to get the way the grand jury operates. Okay, you lost, but move on from it now. And she won't. She's wasting time still trying to fight a battle she knows she can't win. Move on to something else. Stop holding up certain aspects of this. And she's doing it because she wants her summer 2025 trial, and she's made that clear. So, being that I worked in the legal justice system for over 30 years, Lucas, I can say you can see when somebody's trying to stall things so they get exactly what they want, which is a 2025 summer trial. And when you say, oh, well, the prosecution's not being fair, we'll talk fair. The defense hasn't turned over stuff that they were ordered to turn over either for a year now. So it's not just the prosecution. She wanted everything under seal, and now she's crying that it's under seal. Make that make sense. She's stalling. She fought tooth and nail not to have cameras in the courtroom. She fought tooth and nail to have everything sealed. And now she wants the exact opposite. Can you see how a prosecutor and people out in the public are getting irritated? And then you're disrespecting the judge. Okay, so now you're playing both sides of the fence here, Lucas. If for some reason I got falsely accused of something, I would want someone like her on my side. you still not addressed the issues of the disrespect. And her now saying she fought tooth and nail to have everything sealed and no cameras in the courtroom. It ended up she lost the no cameras in the courtroom thing, but it's the judge. Okay, she fought tooth and nail to have everything under seal, wasted all kinds of court's time and everything else and hearings and this and that and blah, blah, blah to get everything sealed. And now she wants the exact opposite. Now she's fighting to have everything unsealed and everything out in the public. And now you're saying he's falsely accused, but just a bit ago you said you think he's guilty. What is it? You're starting to look like a troll. Like I said, I don't mind having a healthy debate with you and trying to give you the respect that you deserve, because you do deserve respect too. But you're starting to make it hard when you're starting to contradict yourself. You just said a while back that you think he's guilty. Now you're saying that you think he's falsely accused. I'm going to have to bring in my jury because, like I said, you're starting to look like a troll now. And you still haven't addressed the respect thing. And that's how I got heated about this, because you thought that it was okay the way she disrespected the judge. I got juror 11 here ready to put that gavel down. And like I said, I love healthy debates like this. I love attacking what is said, not the person. But then when you start contradicting yourself, I think he's guilty, but okay, cool. I left a little bit, and I've told everybody here knows, I think he's guilty, but I'm leaving that door open for things that the defense may, when they cross-examine and show evidence that maybe that's wrong, I'm leaving that door open that she can do that and show the prosecution isn't right. I'm leaving the door open. But right now, I'm at 90, 95% that they got the guy. No, they had to drop it in Lori Daybell's case because Lori Daybell did not waive her right to a speedy trial. And they kept delaying the trial, which went against her speedy trial rights. That's why they had to take the death penalty off the table. Okay, you just did. You just did. For some reason, I got falsely accused, so you're projecting that you think he's falsely accused. And yet, just further back, you said you think he's guilty. And you still haven't addressed the respect, which is how this debate even started. This is how it all started. That you thought that she talked to him respectfully. Is she the only one that deserves respect? Prosecution doesn't deserve it. The judge doesn't deserve it. That's basically what you said. And then when we wouldn't jump on board with that, you brought religion into it. We can agree to disagree. And I respect your opinions for your opinions. But there's a line. If you think he's guilty, stick to it. Don't come in later and say, oh, well, he's falsely accused. Exactly. Why are you bringing religion into it? Religion has nothing to do with it. Stop. And I just said, we don't bring religion or politics into our discussions here. So please don't do that. If you can't make your point without bringing religion or politics into it, then you ain't got a point to make. And I've asked, this is twice now I've asked not to bring religion into this, because I know a lot of Christian people, and I'm not saying you, Lucas, so don't say I'm jumping on you. I know some Christian people that have done some pretty nasty, horrible things. So being a fair Christian is your opinion of yourself, right? I don't know you, so I ain't going to judge you. But don't bring religion into it, because I know a lot of Catholics and Christians and Protestants that are horrible people. So please stop. Last warning. You can tell me who you are without bringing religion into it. Just because you're a Christian doesn't mean you're, and I'm not talking about you, just because somebody says they're a Christian doesn't mean that they're a good person because I'm a Christian. I'm a Catholic. Just because I'm a Catholic does not mean I'm a good person. And I would never project that. I'm Catholic, which means I'm a good, honest person. I know a lot of Catholics that have murdered people. Your religion and what you believe religion-wise, or your religion does not make you a good or a bad person. See, I knew that's what you were going to do. I have made it clear that I was not talking about you personally. And I did not talk about a Christian or anything. I brought all religions. Just because you're like me, a Catholic, I'm a Catholic. That doesn't mean that I'm a good person because I'm a Catholic. And you're trying to project, oh, I'm a Christian. And now you're trying to throw it back at me when I made it clear that I was not saying you personally. I was saying in general, on a whole, I'm done. I'm done. Done. Gone. I can't. Don't ever accuse me. Don't you ever accuse me of something like that. You're gone. I gave you the floor. And really, really hope that we could have an open debate like that. But when you start bringing religion and that's your, and he never did address what started all this was about respect. Never addressed it. Unreal. I tried, you guys, but my patience, I only have so much patience. And when you start accusing me of attacking a Christian now because you're Christian, get the fuck out of here. And I said it. I said the F word. Oh, yes, you did. Like, goodbye. Hello, stay-at-home mom detective. Welcome. Yeah, and because of him, we didn't get a recap. So is there anything that was said, you guys, that, and I can't say that I can, I will give you to the best of my knowledge. Don't forget, I am in Canada, but I am seeing a lot of this runs the same way as the States, especially the respect thing. My throat is so sore now. My Lord. Jesus, take the wheel. And that goes across all religions. Right? He didn't even do that. How many times did I ask him, please address the respect thing? You brought this up and you got this started. I'm asking you to address it. You think it's okay for Ann Taylor to disrespect the judge? He wouldn't answer. And then went on to bring other things into it, and then religion and whatever. Go away. Anybody? Okay. So as of right now, K. Mitch says, is it going to be public or not? It's not. The hearing on the 14th is going to be sealed. Now, what he did say is he is sealing it for now, so it is going to start under seal. And if the judge feels, because he's the judge, and we're going to respect him, he is going to seal the first little part. And then if he feels if the next topics that they talk about or are going to get into can be open to the public, then he will open it up. But as of for now, it is sealed. And I believe both the one on the 14th and the 16th right now are both sealed. He could change his mind once certain things are discussed. They did bring up that the reason why they wanted it sealed, why the prosecution wanted it sealed, is because the defense wanted to go into some of the grand jury decisions that were made regarding the IGG. They were also going to be talking about local businesses and individuals, which they want to protect. We've seen how, what was the name of that restaurant, you guys, when it was brought out that two of the girls worked at a certain restaurant, people were going there and harassing them and stuff like that. So being like that, Ann Taylor wanted it all sealed. All the names of the people that were going to be witnesses and stuff like that. She wanted anything to do with them, any future court hearings, anything. This is way back a year ago. So any court hearings, anything that any of that stuff was going to be brought up, she wanted it under seal. And so the grand jury procedures, the IGG stuff, the motions in the 4th and 5th motions to compel, there was going to be stuff in there that was already under seal in documents that were filed, not so much court hearings or things that had been brought out in the probable cause affidavit or in court hearings that we've already seen. She's not, the prosecution wasn't talking about stuff like that. They're talking about documents and stuff that are already under seal, which is part of the motion to compel, the 4th and 5th motion to compel. There's going to be documents that are discussed that are under seal. So the judge also said that there's also going to be, and Ann Taylor stated there's going to be also things that are discussed during these two court hearings that have already been previously discussed in court hearings or that are already in the probable cause affidavit, and she would like to be able to discuss that openly, like the GPS and the tracking and stuff like that. So that's why the judge said he's going to seal the first part. And if he feels that the other stuff that's already been discussed or is in the probable cause affidavit, as long as it doesn't interfere with sealed documents, that he will allow the court then to be open for that. But anything regarding the IGG or the grand jury proceedings or talking of certain businesses or individuals, that will remain under seal. So that's what he's saying right now. Patty Ward, take care, my dear. Thank you for being here. Get your shit show shirts out. Yes, you guys. I don't know if my sister is still in here. If she can put up the link to my Bonfire store where you can get you got the angel wings, the same ones you see on screen right now are on the back of the shirt without the above and beyond ancestor readings. It's just the wings. And then on the front, it says, welcome to the shit show. That's the trial version you could get. If you click on the trial version, heading. You can get t-shirts, caps, sweatshirts, hoodies, all kinds of stuff there. Or you can get the support shirts or hoodies or whatever. So if somebody has the link to my Bonfire store, can they put it in the chat, please? There we go. Thank you, Juror 11. There is the Bonfire store. And they have got, their stuff is not only less expensive than Teespring, their quality of product is 100% better than Teespring. Their customer service is 100%, and their shipping is a lot cheaper. So that's why I have left Teespring and gone to Bonfire. I'm going to add some more stuff in it, you guys, when I have time. But there it is right there. The link is in the chat. The chat will be up once I end the video. It takes a while for the live chat to process and get up on the video. So, but there you go, you guys. Let me just get this written down because I don't want to forget certain things here. So we're going to wrap it up, you guys. Thank you for coming and watching. I appreciate each and every one of you. Thank you, mods. You guys are the best. I've got the best subscribers. I got the best mods. Like, we rock over here. And it's all about respect here, too. Each and every one of you deserves respect. And there's a line. You cross it, you're gone. Respect each other. Respect, you know, it's a big thing for me. I want this a safe environment for everybody, including those that may disagree with what we think. And there was a lot of things that I did agree with Lucas, but there's things I didn't agree with. We're not going to agree on everything. But the one thing that he never did reply to is the respect. So obviously, if you can't address it or you don't follow it, then I don't care what kind of religion you are. Because like I said, I'm Roman Catholic, and I know a lot of Roman Catholics that are very disrespectful also. So, Kate Bell, thank you. Thank you so much, Kate Bell. I appreciate you. Big hugs, big hugs. So we're going to wrap up, you guys. I'm going to keep an eye out. And what's going to happen on the 14th, if they do decide to pop it up, I'll get a notification for it. I will just have to pop up, drop everything I'm doing and pop up live for you guys to bring it. But I have a funny feeling it's going to remain sealed. If today was any indication of how things are going to go, I think it's going to all remain sealed. It's yet to be seen. It's yet to be seen. So we'll have to wait and see. So with that being said, you guys, I'm going to end it like I always do. Please take care of yourselves. Please stay safe. Always be aware of your surroundings. I love you guys to the moon and back. Bye-bye for now.